Sam is like the expert on Naples contracts, and you're involved in putting it together and all that. So we're very, very lucky that he has volunteered his expensive time to share his expertise and knowledge with us. Hopefully that will translate into some business for both of us. I brought the appropriate coffee cup this morning, so when you do it with Sam, you might get a really good coffee cup.
There you go.
With Paradise Coast title, and in case you forget their phone number, it's on the coffee cup.
That's right.
So,
very important coffee cup.
Absolutely. So we're going to turn it over to you, and Sam will set the rules if he wants to let you guys do it as a forum or more of an instruction kind of a thing. So without further ado, there you are, Sam.
All right, so we're going to talk about the changes to the contract, and that'll probably take about 20 to 25 minutes because we didn't do a lot of changes. And then I will open up the floor. First of all, we say you can interrupt me anytime. But I will open up the floor to questions at the end and stay as long as needed to get everybody's questions answered. But we're going to go through the red lines. I'm going to share my screen. Give me a moment to do that.
Are they already published, Sam, so that app files is going to be in there?
App files. Can everybody see where it says addendum to listing contract? So they're in app files, they're in form simplicity. They're on all the major services. Okay, you have a little spotlight here. Hopefully everybody can see that now. Okay, so I'm going to go through the red lines. Like I said, not a lot of substantive changes, but there were some. We're going to talk about clear cooperation. We're going to talk about FEMA a little bit, and then questions, just interrupt me. A lot of what we did was cosmetic changes, so I'm going to breeze through that. But if you don't have a specific familiarity because you're mostly used to the FAR contract and you have a question, just interrupt and ask. So let's just jump right in. So first up, the first thing we did is we just cleaned up this addendum to the listing contract. So NABOR offers a listing contract that I'm going to go over in a few minutes that's separate from the, let me block my phone here, give me a second. Separate from the FAR listing contracts. It's got a lot of similarities, but one of the things you can use is you can attach this addendum for limited brokerage services. And we just made some minor cleanups here. Brokerage services was capitalized and things like that. So this is a great form if you're not going to be doing a full listing thing and you're just going to be doing some limited services like posting to MLS or putting a lockbox. You can use this form. Okay. The next thing we did in NABOR, and I don't even know if FAR has a CDD MSTU disclosure that's correct under state law, but we used to have it as an addendum to the sales contract. It's now a disclosure, which you actually could use with a FAR form, although we always say never mix the forms. But now you put the, where's the spotlight again? You put the seller, oops, put the seller information here, put the property description, the address here, put the name of the CDD here, and then you put your balance, your capital assessment. This is the capital assessment balance. There's the current annual installment for capital, the current annual installment for maintenance, and then the balance, the total goes here. And this should match what's on your tax bill. So if you look at the tax bill, you'll see a CDD payment every year in the non-ad valorem assessment section of the tax bill. Those numbers should match. And the same thing if it's an MSTU instead of a CDD, which they're kind of the same thing. And then we cleaned up the language here to make it so that this disclosure is given in conjunction with the sale of the property, and the property is defined up here, of course, right here. So basic cleanup, and then you always know you're using the right form. See here where it says the 2021 date. That's how you know you're in the right forms, if you have 2021 as the date. Okay, So NABOR, different than FARBAR, offers post-closing occupancy and pre-closing occupancy addendums and amendments. FARBAR just has you fill out a simple form and then enter into a lease. And NABOR, we don't think that's the right way to go because a lease causes all types of other problems, particularly in COVID, with evictions if the seller doesn't vacate. So we have this post-closing addendum, post-closing occupancy addendum, where the seller, you put the date here for when they're going to move out, you put the occupancy fee here, you put the deposit here, you put the number of persons and the pets, and then we cleaned it up so that the standard for when the seller leaves the property, it's in broom clean condition, free of debris, with ordinary wear and tear accepted. This is the same condition as the contract states. And it's very similar to the condition of the FARBAR. And then of course we added down here, instead of an eviction, you've always had a right of ejectment, which is an easier, simpler lawsuit than an eviction. And then we say, and on the other remedies available under Florida law. And then we also limit the seller's liability to negligence or willful misconduct, so they can't be sued for basic, little things that happen. Okay. So we used to have a COVID extension in NABOR. We took all that out and just created this simple extension form. So you can change the closing date, the finance contingency, the inspection period, the due diligence period, the title exam, or the clearance period on one form. And you just fill this out. And what we did here is, it used to be the COVID language. We took all this stuff out. And now you just have one nice form for extension of these deadlines if you need them. Okay, so we changed. This is a cosmetic change. This form used to be called cancellation notice. Now it's called termination notice. So when you're in your form simplicity or your app files or whatever program you like to use, zip forms, all the T's line up now. So termination for other reasons lines up with the termination for the fact that the condo documents were not acceptable to the buyer. So that was just a cosmetic change. Okay, in the NABOR contract, very different from the FARBAR contract, you have an inspection regime that you have to follow through to get your deposit back. If it's not like the FARBAR regular, not the as is, the seller's obligated to a percentage of the purchase price. NABOR is different. It doesn't do that. It gives the seller the option to reject the inspection election, and then the buyer can terminate and walk away. So this form walks you through that process, and we made some changes. There are only 6 specific items that you can use or complain about, I should say, in the NABOR contract. The systems and equipment, radon, lead-based paint, WDO, mold, and unpermitted improvements or open permits. So there used to be this other thing, and that's not in the NABOR contract. So we took that out. And then if your buyer makes an election here in part 2 that's improper, they ask for things that are cosmetic to be corrected. The seller, instead of getting into a big fight with the buyer, can just sign here and accept the election as to defective items only. And of course, defective items are defined in the contract and not as to cosmetic conditions. Yes, JJ, you're on mute again.
Quiet. This is only for the standard contract, right?
Only for the standard, not for the as is.
I wanted to just clarify that for everyone.
Yeah,
Okay.
so don't use this form for the as is in NABOR or FARBAR, but in the NABOR regular residential improved property contract, this is the proper form to use. And it goes with the next form, which is the list. So you take your report and you make a list of all the problems that are actually defective and not just cosmetic. And you put them on this form and you attach it to this form. And then you can submit the whole package with the reports to the seller for response. Now, I will tell you and remind you in NABOR, you have to submit the full report. You have to submit all the reports. You can't just pick and choose. Okay. So questions about all that before we get into the listing agreement? All right. So the listing agreement, we did not make a lot of changes except for here. This is for rentals, and we made the changes. Oh, this is the vacant land one. I'm sorry. This is the vacant land one, but we did this in all the listing agreements. We cleaned them up. Where's the changes? Where is the vacant land? Okay, so yeah, so we made the disclosure. We changed it from addendum to disclosure. I thought we did something else in there. Let me look. We made it so you had 5 lines for changes. And then we added the date. So when the authorized broker signs, they can now date the contract. Before that wasn't there. Okay, this is what I'm looking for. Here's the listing contract, the exclusive right authority, the rental, and the sales listing contract. We made a bunch of changes. This is a cosmetic spacing change. So everybody knows clear cooperation. JJ, you're enforcing clear cooperation as much as we all hate that. Yeah. So we had to change the listing agreement to say that the property will be entered in the MLS within 5 days of commencement of the listing, or within 1 business day after the public marketing commences, whichever is first. You could always check this second box and not do any public marketing, but you know now clear cooperation means you can't do any of these items down here. Open houses, flyers, displays, yard signs, digital, public facing websites, broker websites, IDX, Vox, digital communications, email. You could only advertise inside your brokerage. So that is a major change, and we had to clean up the listing agreement to reflect that. Okay. We added the lines. This isn't properly formatted in this PDF, but you have 5 lines for other terms and conditions, and the date was already there. Okay. So this is your main listing agreement. This is what you would use the right and authority to sell. And we did some cleanup, but here's what it looks like without all the red line. So 1 business day after public marketing defined below, you have to get it into the MLS. And I thought there was, maybe it's a change from 2 years ago, but I thought it was a new change. That's just a formatting. Where is the part? I apologize. I thought I had it highlighted. We added in here the language about non-discrimination. You can't discriminate based on anything anymore, but I'm trying to find it so I can show it to you.
Now, would that be informing the sellers that they're not allowed to, or just informing them that we're not allowed to?
Both. Okay.
Because we're running into that frequently.
Yeah, are you finding that's going to offer a better layer of liability protection to us as realtors?
It absolutely does. If I could find the darn language, I would show you why.
Yeah, the 7 protected classes. We've got it.
Well, there's protected classes, but there's also
The wonderful little thing about hate.
Here it is. Okay, here it is. Broker shall be a salesperson regarding race, color, national origin, sex, handicap, disability, familial status, religion, sexual orientation, gender identity, and any protected class under applicable federal, state, and local fair housing laws. Here's the part. Broker shall not be required to violate any provision of the Code of Ethics as amended from time to time. So you may have a seller who says, you know, don't rent to Black people. I don't know, whatever it is. And or don't sell to them. You can still sign this agreement and you would not be obligated to follow their requirements, and you could bring any buyer or accept that is deemed worthy for credit and other reasons not related to any of these protected classes. And if the seller were to do something I would argue that you would still be entitled to your commission because you followed the law and the contract says you don't have to discriminate because the seller wants to.
Your broker said if you get a seller that's like that, call me first.
Yes, I would probably walk from that seller if I were you, but
Yes, that would be my advice.
but you know, you might not, they may be subtle about it. So there may be a situation where you just notice that there's a problem and then
We
you
usually get
have
it
the
the other way.
protection.
We usually get it the other way. I only want you to sell to this particular group of people. How about that?
Yeah. And then we added the date. I don't know why this wasn't properly dated. Okay. So this is the as-is, the NABOR as-is contract. It's just like the FAR-BAR in a lot of respects. It's a free look. We cleaned up the top part there, cleaned up some spacing, fixed the disclosure versus addendum, spacing issues, clean up. Don't worry about all this. Okay. So there's now a NABOR fair housing brochure that you need to use. It's not a NABOR, I think it's a state brochure, but I'm sorry, it's an NAR brochure, and it talks about equal housing opportunity, and it is now represented that you acknowledge receipt, that the parties acknowledge receipt of the brochure. So you should include the fair housing brochure, which also is in Form Simplicity and all the others. When you do your contract, I would do this under FAR-BAR and NABOR just so they have it. Just a layer of protection for you as the realtor. You've disclosed that. The other thing we added here is about the FEMA 50% rule. So FEMA, Federal Emergency Management Agency, controls the floodplain and the flood maps. If the property is below the floodplain, you cannot perform certain reconstruction, rehab, or additions or other improvements without compliance with the floodplain rules. If you do want to do work on a property that is below flood, you can only expend up to 50% of the value of the structure at any one time. So you can't just remodel a whole house that's below flood without bringing it up to code above, which is 1 foot above the flood map line, the firm. So that is a limitation that we wanted to make buyers aware of, especially when they're ripping down a lot of houses in Collier County and putting up new ones, bigger ones. That's a big deal in Collier. I don't know. Is that a big deal in Lee County too, JJ? Is that like a big thing right now?
Starting.
Yeah, I've got a couple of clients that are big into that in Lee County. Okay, and then we added here extreme weather conditions. So NABOR did not have the same or any really force majeure clause like the FAR-BAR contract does. So we added this provision here: if due to a pending threatened hurricane, tropical storm, or other extreme weather condition, the buyer is unable to obtain flood, hazard, wind, casualty insurance at a reasonable rate for closing. This is really important, the next part. Or if services essential for closing are not available, then you can delay closing for up to 30 days. So what are services essential for closing? Well, the bank, FedEx, me, the buyer and seller,
Okay.
the insurance company, lender. Those people are all really, really important. I joke about it. It's kind of funny. The realtor, once the contract is signed, is not essential for closing. So if you are unavailable due to weather, we can still close. And of course, we'll wire you your commission check. So, but this just says that the services essential for closing are not available, or if we can't get insurance at a reasonable rate because of the weather, then the buyer can delay closing for up to 30 days and possibly walk. It's another out for the buyer. Okay. Any questions? Everybody good? Okay. And then we added this. So there's a lot of problems where sellers are allegedly rejecting these offers, and the buyer realtor community seems to think that the listing realtor community is just not turning them in. So now there's an option here where the seller can reject and sign in writing, no, we reject your offer. And some people seem to like that. I've never seen it used. Okay, this is the sales contract. This is the main document that most people in Collier will use and that you should use in Lee County with your buyers in particular. I'll talk a little bit about it as we scroll. It's got a much more comprehensive personal property definition, including washers and dryers, which are not in the FAR contract. And then the finance contingency is much more friendly to buyers in that if the buyer doesn't get financing after the 30 or 45 days or whatever it is that you agree on, it's not that the deposit is lost, it's that the seller gets a right to terminate the contract and move on to the next party because the financing is taking too long. So that's a big difference from FAR. The NABOR contract is the better contract when you have the buyer and you're doing financing in Lee County. I will say that another nice thing about the NABOR contract in Lee County is that if you have your buyer gets to pick the closing agent, even though the seller pays for the closing agent. So that's a big difference from the FAR contract as well. And that is further down in here. Okay, so the other thing we had, we made it so that if you you give marketable title at closing, but if you have a condominium, it's still subject to the condo docs and declaration, which everybody knew and was always thought to be correct, but it was never in the contract, so we added it here. And then let's see what else. Okay, we did the fair housing and FEMA language, and then now this contract, this NABOR regular contract, always had it so that it was 15 days for the inspection period. Now there's a blank with a 15-day default. So if you want a shorter inspection period under the NABOR contract, you have that option in the blanks and you don't have to write it in the additional terms. And then, okay, so this looks like a lot of redlining, like we've changed the inspection election process a lot. We did not. It's the same process. Buyer has the 15 days to get their inspections. Buyer then decides whether they want remedial action or a credit or a combination. Buyer makes their election on those forms I showed you earlier. Buyer submits the forms within 5 days after the end of the 15 days inspection period. And then the seller has 10 days to respond on those forms. Now, what we did change here is two things. Except for buyer's permit election, the buyer shall be entitled to one buyer's election. So you get one bite at the apple with your buyer under the NABOR contract. You come in, you give them the inspection election, and then the seller makes a decision about acceptance or rejection. And then the buyer either goes to closing or terminates. And you only get one shot. It's not like you can add multiple things. You can't come in and say the roof is bad and then agree to that. The walls are bad, agree to that. The permits are open, agree to that. So except for the permit election, which we deal with down here now, you get one bite at the apple. So what do we do for permits? So because permit searches are taking so long to get back from the counties, we're now saying that up to 5, as long as you make your request for a permit review to the county within 5 days of the effective date of the contract, you have up till 5 days after buyer actually receives the permit to make an election to get open permits or unpermitted improvements closed. And then the seller has 10 days again to decide. And nothing in this paragraph extends the closing date. So whatever you want to do has to be done by closing. Does everybody understand open permits? Okay. The other thing is here now is as far as things that need to be corrected. If you have wood rot, you know, when you get the wood rot around the doors, the base of the doors on the outside door in a lot of homes, that all has to be corrected under the NABOR contract. You can't have door jambs and doors and windows with a bunch of wood rot and call it cosmetic anymore. It now is free from wood rot. Okay, we did the same thing here with the extreme weather conditions. I talked about that. Excuse me. And then again, the seller can reject in writing. That makes buyers feel good. Okay, the vacant land contract. I thought there was one more thing on here. No, the vacant land contract. So we cleaned up some spacing issues. Changed this from addendum to disclosure. Again, with the condo. And then we cleaned up these. We added the fair housing, the extreme weather to the vacant land contract. And then that's a spacing issue. Another spacing issue, comma there. So that's all we changed in the vacant land contract. Very simple. Okay, so the termination notice. FARBAR, I don't think, provides termination notices the way NABOR does. NABOR provides a variety of termination notices. This is a comprehensive buyer notice. So if the buyer can terminate for any reason, which there are a lot of them, under the contract or the addendums, then they can just check the box here. You fill in the information here, seller, buyer, property. Check the box here, and at the end, sales, we clean this up so it's all in alphabetical order. Then you just sign it and turn it over to the seller, and the contract is terminated. And we cleaned up, again, we cleaned this up to put these all in proper alphabetical order is all we did. Make them match, and we made the titles match what the contracts actually say. Okay, that's it for changes, JJ. That's all that we did not do a lot this last year because of there just weren't a lot of suggestions from the realtors, and we didn't want to make a bunch of changes that people didn't ask for, although there's a bunch of stuff I want to change. With that, let me open this up to questions. Generally, I've got the NABOR contract. I've got the as-is contract here. For those of you that either practice in Collier or want to use these forms in Lee, what can I additionally tell you? What other questions do you have? Don't everybody jump at once.
I think the biggest difference when our agents start looking at NABOR versus the FARBAR is all of the differences in times from the inspection periods. I think that's the part that they can get tripped up the fastest.
Sure.
You got 15, 10, 5, and maybe discuss that. Are Candy and Troy, have you guys looked at the as-is NABOR versus the standard NABOR? Have you gotten a chance to take a look at it?
Yeah, we've looked at it, but we've never had opportunity to use it. We really just used that leak.
So
Maybe you could touch on that piece of it, because that seems to be the biggest difference in the contracts.
Sure. So the big difference here is standard D, 2, A, B, and C. What I would say is you need to know the deadlines. You have 15 days after the effective date to do inspections. You inspect your 6 things that are listed here in the contract in front of us. Let me zoom in on this. Your 6 items here. Then once you have your 15 days, and you don't have to take all 15 days, then the buyer has 5 days, not later than 5 days, to make an election about how they want to proceed, either with remedial action or a credit or a combination.
And this is on the standard.
On the standard. And then the seller, once they receive your election, your buyer's election, has 10 days to decide how they want to proceed. And I will tell you this. see here where it says I've highlighted complete inspection reports and buyer's election? I'm working with another broker who just got an email from a Naples real estate attorney who's, when the buyer submitted their buyer's election, they did not send the complete inspection reports. And the lawyer saying, well, you didn't make a proper inspection election. We're not fixing anything. And I think that's the right result. So make sure that you get your complete inspection reports along with your buyer's election in within the time period, within your 20 days. That's your 15 plus your 5, so that the seller can properly respond. Now, if the seller responds with an acceptance that they will repair or give a credit, then the buyer must go to closing. If they reject or counter, then the buyer has 5 days prior to the closing date to terminate the contract. Does everybody understand that? 15, 5, 10, 5. Those are the deadlines. Now, in the as is, of course, it's a free look for whatever the negotiated time period is. If buyer shall 15 days after the effective date have the property and personal property evaluated at their expense, they don't have to use a licensed inspector. They can use whoever they want. If the buyer determines in buyer's sole discretion that the property is not acceptable for any reason, buyer may terminate, which is similar to the FAR bar. Questions about the inspections?
So does that create a much longer closing time because there's so many more days in the standard?
No, as a matter of fact, the standard also contains a hurry-up clause. Where is the hurry-up provision? Where's the hurry-up provision? Somewhere in here it says that you have to do everything by the closing date. I gotta find it.
And once everybody closes, it's done. So.
Yeah. Quick close. Here it is. Didn't go far enough. So there's a hurry-up provision, except for the clearance period, which extends for title commitment, title defects, and then standard J, which is the right to examine documents for this HOA. Everybody agrees to get their stuff done quickly. So if you got a 30-day close, you can't take 35 days to do the inspection process. Everybody's got to go faster, buyer and seller. Okay. Other questions?
I'm going to ask, because most people forget about it, time. How is time computed on the NABOR contract? Is it the same?
It's actually the same as the FAR bar with one exception. Everything goes to 11:59.
Okay.
Except if the closing date or deadline falls on a Saturday, Sunday, or federal holiday, the deadline is extended to the following business day. The difference is FAR bar says 5 p.m. on the next business day. NABOR says 11:59. So that's the difference. But otherwise, it works the same as the FAR bar. Let's see, what else can I tell you since I'm here? So this, I get this question a lot. This is the integration clause here. You don't get to come back and say under either contract that, oh, that was in the MLS, so it counts. No, if it's not in the contract, it's not in the contract. It's not a part of the deal. So don't get hung up. People will say, well, that couch was listed in the MLS. Well, it wasn't in the contract at the top of the contract under furniture that's staying right here. Wait, this is the.
Glad you brought that up, because that seems to be a big rabbit hole for a lot of people, because they look at MLS and they see the word turnkey, they see the word furnished, and then they don't see an attached inventory sheet. And FAR bar doesn't have that form available. Thank you, Naples, for doing that.
Naples has the inventory.
You do have one, yeah. So what would you recommend to our buyer people, our buyers agents, on how to handle when they see turnkey, furnished, or whatever?
Put it in the contract, right here.
Right
in
in.
this blank, where the red dot is. Turnkey, furnished, see attached inventory.
Okay, and if there isn't one,
Make one.
and you're the attorney, can they just write, seller to provide inventory list for buyers review and approval within X number of days after written acceptance?
NABOR.
I love the name. I do say love the NABOR inventory form. I will say that. I wish that our association, or I really wish Barbara would put it back in. They used to have it 100 million years ago when I was on forums.
We have an inventory addendum. 10 days after it takes less than 10 days. 5 days after the effective date, seller delivers an inventory. Buyer has 5 days to review and terminate or move forward.
Okay.
So you can attach this personal property inventory addendum,
Okay.
and then you can do your inventory after contracting.
Okay.
I have a question with this section saying that MLS basically doesn't matter. Seeing kind of lazily or sloppily, we're seeing a lot of people writing as seen in the MLS in certain parts of the contract. Does that mean that's not going to fly in Naples, even if they write it in? How does that work?
No, that's different. If you
Okay.
write in there as seen in the MLS, you just integrated the MLS listing into your contract. That's actually a good idea. If your
Okay.
buyer expects there to be a bunch of stuff that's listed in the MLS in the deal, and you don't want to specifically write out those items, then you should write as seen in the MLS or CMLS for details for inventory details, for picture inventory. You could use that, and then you could override that integration clause. I'm trying to find it again, but you could override that.
Cautionary from your broker. If you do that, make sure that you have a printout of the MLS on that date that you write your contract. So you
Well,
have.
it should be attached to the contract.
Yeah.
So when you send it through the DocuSign, that should be something that they is attached and part of the whole contract. So print out the picture inventory from the MLS.
Yes, I like that.
Like attach it as one PDF, so that when it gets through the DocuSign and the judge sees it, oh, well, this was attached as part of the whole contract.
We'll have your buyer's initial and date it.
Yeah. Now the initialing thing, you can do that. The FAR bar has you initial every page. The NABOR does not, because it's not necessary.
No,
For
I agree. It's not Scrivener's errors.
Okay. Other questions you all have about these contracts?
I have a question.
Yes.
As a seller's agent, I'm not sure I understand the benefits or the difference of why between the standard and the as-is contract. As a listing
So-
agent, I would only want the as-is. I don't understand the standard. Is that just the buyer's request?
Yeah, I mean, when their buyer makes their offer, the thing with the NABOR contract is, the regular contract is kind of an as-is contract. It requires the buyer to go through an inspection process. But at the end of the day, if the seller won't fix anything, the buyer can get out.
Mhm.
So I wouldn't sweat if you see a regular NABOR contract and your seller's demanding an as-is. I would just say, okay, well, we just won't fix anything, or we'll negotiate something as they go through the inspection process, because we're not obligated to fix anything like you are in the FAR bar.
Got it. Thank you.
Yep. Anybody else?
I have a question on the inventory form. Can we take the NABOR inventory form if we're using a FAR bar contract?
So as a NABOR adherent, I would say no, but the reality is you can do that. This contract doesn't rely, this addendum for personal property inventory does not rely on any contract terms that are in the NABOR form that aren't referenced in the FAR bar, so you could use it.
Okay,
We always say don't mix the
Tricky part
form.
of it says paragraph such and such, then you've got to reference it to that contract that it works with it. So you don't want to,
But you don't have that problem here.
yeah, you don't want to do Crispies and FAR bars and NABOR, you don't want to make it look like a big mess.
Other questions?
We have a super intelligent group this morning. They know everything.
Everybody's ready to go.
Have you been seeing anything interesting in this
So I-
marketplace? You know, where people are using different terms for negotiations. I was reading something this morning where they were talking about one of the negotiation tactics might be to release the security deposit after a few days to make the contract more interesting to the
Yep,
seller.
you do non-refundable deposits, which basically turns your contract into an option. You can do all types of things, multiple offers, sight unseen. You can do escalation clauses, all types of stuff.
Yeah, we've been using those. I didn't know if you saw any kind of a trend down in
A
Naples.
lot of escalation clauses down here. I don't know if you're seeing that in Lee County, but Naples has seen a lot of escalation clauses.
Yeah. We are as
I have
well.
one pet peeve I'm going to bring up, JJ. When you are doing a 1031 exchange, you do not have to write anything else into the contract. We have done it for you. Right there.
Okay. Well,
So-
thank you for that.
Drives me crazy. I see buyer is doing a 1031 exchange. Seller agrees to cooperate. I'm like, it's already in there. It's okay. Other questions? Anything else? All right, JJ, what else do you need from me?
I think that's great. Thank you so much for taking time again to do this. You know, if you guys have some questions or you think of something afterwards, email Sam, you know, give him a call, ask. And remember that we share their offices. So if you have customers that you need to meet down in Naples, you call his office and schedule an appointment time so you can use the conference room and so
Yep.
forth. Just like he uses our Cape and Fort Myers office. So we're really lucky to have that kind of a fantastic relationship.
I love it. Oh, there's a chat. Hold on.
Well, that might have been my chat from earlier.
Oh, would you recommend asking the HOA to come? What was that question?
That was relating to the CDD form, which which Harvard doesn't have. You know, who's going to take that responsibility for putting those numbers in there? Sometimes the sellers just have not a clue. You know.
It's all online. If you can't figure it out, call me. I'll help you. All those numbers are public records, and they're all available through the various CDD and HOA websites.
Okay.
Great. All right. Thank you all very much for letting me talk to you today. If you have any questions, you call me anytime.
All right. Thanks again. Have a
Thank
wonderful
you.
day.
Bye-bye.
Thank you.